Guys, can you see the screen?
Yes.
Okay, perfect.
So we can start, Professor.
Yes.
We organize with 30 minutes to 40 with the presentation, and after that we can discuss with you. It's okay?
That is perfect.
So I think we can start.
Okay.
Professor, thank you very much again. Thank you everybody that is with us today. We have another webinar in our series discussing private law and technology. And today we receive Professor Jay Kesan, that is a professor in Illinois, University of Illinois at Urbana-Champaign in the College of Law, and is an expert in the subject. Professor, thank you very much. I think you can start now.
Good morning, everyone. Thank you, Professor Rafael Dresch, for inviting me. I'm pleased to be talking about this topic. I'll first begin by looking at data from a privacy perspective, and then look at it from security perspective. Are you guys hearing an echo in the audio?
Yes.
Yes, we are.
Yes, a lot of echo.
Wondering where that is coming from. Now I don't hear it anymore. Do you hear it now?
No, it's okay now.
Oh, perfect. I don't know what happened, but okay. Perfect. So, as you all can hear me now?
Yes, it's good now. Thank you, Professor.
Perfect. So, as you know, there is the General Data Protection Regulation in the EU, and you may have studied it, and maybe you have some other speakers who are talking about this issue. As you know, the GDPR, protects the processing of personal data. And I put personal data in quotes because that is what the GDPR calls it. In the US, we usually call it personally identifiable information, PII. Now, the GDPR, of course, is a European law. However, if you have a website in the US, and if there are companies and entities that then present these websites to EU citizens, then of course they must comply with the GDPR. So from that perspective, a lot of American companies and businesses have to comply with the GDPR, even though there is no US data protection law. Now, the US companies employ one provision in the GDPR that says that, yes, you can process the personal data of data subjects, that's the language in the GDPR, as long as you obtain clear and unambiguous consent. So this consent is a legal ground that allows you to process the data of your customers and the people visiting your site. The GDPR also requires that these people be able to revoke consent, and it also requires that you seek to renew consent regularly. Of course, there are some other legal basis for processing data as well, due to a contract or trying to protect the vital interests of data subjects, so on and so forth. But basically, you need one of those legal bases to process personal data. And that is still true for many US companies doing business all over the world. Having said that, before we look at how US companies comply with the GDPR, let me step back and tell you a little bit about data protection in the US. There is no federal law that governs personally identifiable information in the US. It is a political matter. There's a lot of lobbying on all sides. Several hundreds of millions of dollars are spent by companies like Google and Facebook, etc. And so, it remains to be seen if there will be a federal law and what form it might take. Having said that, there are a number of states that have already begun legislating at the state level. So just to give you a couple of examples, we have the California Consumer Privacy Act, and there is the Nevada Privacy Law, which is really an addition to a previously existing law that governed online transactions. And it has provisions that are sort of, quote unquote, GDPR-like, but they are different. It does allow, for example, California citizens have a right to opt out of sales of their data. It gives them the right to see what data has been collected, and they can request that certain data about them be deleted. So the CCPA is effectively the most prominent data protection law that we have in the US from the privacy side. The Nevada privacy law also gives Nevada residents the right to opt out. Now, in addition, if you're a US company and you want to make sure that you can qualify as a country that is compliant with the GDPR, since the US, broadly speaking, is not, this Privacy Shield program has been developed by the US Department of Commerce, actually the International Trade Administration in the Department of Commerce. So there are these two Privacy Shield frameworks. One is the US-EU framework, and the other is the Swiss-US framework. And they provide companies with a mechanism to comply with the data protection requirements, and that then allows you to process data transfers between the EU and the US. So in other words, the US Privacy Shield is a way to ensure compliance with the GDPR in the US. So in the absence of a federal law, this is kind of where we are. I'm hearing another conversation is, are you able to hear me or no? Are you able to hear me?
Yes.
Yes.
Okay, thank you. So this doesn't mean in the US that there is no data protection laws. From the privacy perspective, we really have only this state laws. But from a security perspective, now if you're an entity that has data, then you must protect that data. And so from a security perspective, there's a lot of laws. So these laws allow companies to protect data of their consumers. You can imagine that as a company, you want to make sure that the data you have some legal basis to protect the data. And so these are some of the laws and regulations that are in place. Let me begin by talking a little bit about tort liability for data-related injuries. If you are a consumer and your data has been compromised, the key question is, imagine that there is some e-commerce company, Target, which was the subject of a big data breach, and your personal information has been compromised. Can you sue Target? That's really the question. Can you sue them because you have suffered an injury because they did not protect your data carefully? Now that question, the law on this, as decided by the courts, is slowly changing. You're seeing one or two decisions that seem to allow people to sue a company if they don't protect the data carefully. I have an article on this called Liability for Data Injuries that you're welcome to look at on the Social Science Research Network. But the point here is this. Is there a legal duty to protect data, to secure data? What I suggest in my work is that very often companies underestimate the amount of cyber risk that they face. And they very often think it's not going to happen to me, or so on and so forth. There's a whole bunch of cognitive biases that result in a systematic underestimation of this risk. And so what I suggest is that there should actually be a legal duty so that parties are encouraged to engage in a process of managing and reducing their cyber risk. Now, the problem is that courts have a lot of difficulty with recognizing that data insecurity is an injury for which we need tort liability. Of course, it's a privacy injury. And of course, it affects our lives. And of course, it affects our ability to take decisions with respect to our lives and creates a lot of anxiety because we have to go and pay money for credit monitoring. We have to go cancel credit cards, do all these things. But courts have been unwilling to find data security to be something that is the basis for a tort claim. Now that is changing. The Seventh Circuit a year or so ago had a decision that said that in fact there is money being spent by people whose data has been compromised, and so they are entitled to compensation. In addition to this tort liability, the biggest statute that really protects data in the US is the Computer Fraud and Abuse Act. And this prevents outsiders and insiders from accessing your data. So this is actually an old law and has been around really for 35 years, and it has been rewritten several times. The main statute is 18 U.S.C. section 1030, and it defines protect protected computer very broadly. In fact, I've got the definition here, and if you look at section B, it basically says it includes any computer that affects interstate commerce. So in fact, any computer that is online is considered a protected computer. And so what the CFAA does is it provides both civil and criminal penalties for a whole variety of actions taken by people. And I've just provided a list of various kinds of unauthorized access to computers, data, etc., and causing damage, etc., etc. Most of the CFAA violations are misdemeanors. However, there are some longer sentences, provided there are certain aggravating factors. Now, this is on the criminal side. I'll get to the civil side in a minute. Nevertheless, the CFAA is controversial. It's controversial because it basically says you must be unauthorized or you must exceed whatever authorization you have. Those are the two big categories for falling within the CFAA. Now, the problem here is, what do you mean by exceeding authorization? Many of these websites have all kinds of terms of use. Is violating a term of use exceeding authorized access? Facebook says you must use your real name. What if you use some other name? Is that a violation of CFAA? These are the kinds of issues that are coming up. Now, generally, the statute says without authorization, the sense is that that is about people who are trying to hack in, or people who are trying to who really are outside the company. But then exceeding authorization is seen as something that somebody inside the company does. So for example, you're working in the finance department in a company. Why are you trying to access the HR computers? Why are you trying to access human resources information? Maybe you're not allowed to do that. And that would then put you in a situation where you're exceeding authorization. And in many civil cases, courts have said that you owe a duty of loyalty to the company. And you might be acting without authorization if you breach that duty of loyalty. Now, some other courts have said that in order to exceed the scope of authorization, the computer owner or the company must explicitly revoke your authorization. They must tell you, okay, you cannot, you had this access, but you don't have it anymore. Maybe you're fired, maybe you're demoted. The others who say that you have a duty of loyalty, even if the owner does not know that you've breached that duty of loyalty. So it doesn't matter. You as an employee, you have a duty of loyalty and you have to stay within the scope of your employment authorization. So there is some discussion about these things. The issue of exceeding the scope or violating terms of service is a huge issue. It's a huge issue and there's a lot of litigation. One of the most celebrated cases involved the Drew case, where somebody tried to impersonate somebody else, and that then resulted in this teenager committing suicide. And so it really was a very sad and a really difficult case. But it was hard to say that this was a CFAA violation, and the courts, agreed that it was not a CFAA violation. There are other issues like what counts as damage and what counts as loss under the CFAA. So, you know, if you download some files and you copy some company secrets, is the downloading, is that part of the damage? If you then try to erase some files so nobody can find out, is that also considered damage? What if you shut down some computers and shut down some network in the process? Is that part of the violation? What if the company loses some profits because of what you've done? Then is that also part of the damage and loss? So there's a lot of issues about what is foreseeable and what is consequential in the CFAA. So I just wanted to give you a sense of the kind of disputes that exist in this area. Finally, you do have civil actions under the CFAA, but imagine why they don't really provide a lot of help. Why? Because, you know, if your data is compromised, you know, if you can go after some penniless 16-year-old who hacked into some computer, that doesn't do you any good because you know this what are you going to gain by bringing a civil lawsuit against the teenager? What you really want is to sue Target or somebody else, you know, not the hacker, you know. But nevertheless, it does allow you to proceed against somebody who violates the CFAA. But the important thing here is that people who design and manufacture software, hardware, the companies, they cannot be sued for negligent design. So they cannot be sued for having, you know, all sorts of vulnerabilities, all sorts of software and hardware vulnerabilities, and there can be no negligence claim made against them. I want to tell you a little bit about some of the international aspects since we're really, we're talking across countries here. This is an interesting case where you might remember Ross Ulbright. He was the guy who founded the Silk Road. This is the dark net website that was trafficking in narcotics and money laundering and so on. The FBI agent who ultimately realized that this Silk Road server is located in Iceland, he essentially used a sort of a hack-back type approach to try to get information about this server. Now the question really becomes, can you do this kind of hack-back, or can law enforcement hack into some suspect computers without a warrant, especially when they're located outside the US? So what does the CFAA say about that? So this is kind of an example of that situation. Another situation, which is also interesting, involves South America, is the case of Ubiquity Networks versus Koizumi. They're both US companies, but Koizumi sold computer networking hardware under the Ubiquity name, except that they got it from China and they sold it. It went straight from China to Argentina and never entered the US. And so then the question became, in this kind of situation, you know, how do you exercise jurisdiction over, you know, parties when the US is not involved? In this particular case, because of the Trademark Lanham Act, it allowed extraterritorial jurisdiction, and that's why they could actually do it. But normally, the biggest problem with data protection all over the world is that somebody who hacks in to your computers from outside the US, you have very difficult, just almost impossible to get personal jurisdiction over them. And so it's really very difficult to do much. And as a result, it raises the question of, can you engage in active defense? If you're a company in the US, can you hack back? Can you do these kinds of things? And that's a big issue as well. So bottom line is, there's a lot of people who are pushing for various kinds of reform of the CFAA, really to make it possible to provide more meaningful protection to data. I want to talk a little bit also about data breach legislation. This is a situation when you're a company and you have a lot of important data about your consumers, and let's say it's breached. Today, data breach statutes exist in all 50 states. There is no federal data breach law because companies are concerned that if there is a federal data breach law, then that might actually be quite strict. So currently what we have is a whole bunch of state laws that vary all over the place. There's variations about, what kind of information qualifies, and I'll tell you a little bit more about that. It's also, if you're a company and your data is breached, then who do you have to notify? Is it enough to simply notify the state government? Is it enough to just notify the Secretary of State in your particular state? Or do you have to actually notify consumers? And by the way, very few states allow the consumer to sue. So going back to my simple example, under the data breach law, very few states give you a chance to sue Target because your data was compromised. Now, there's a lot of scholarly commentary and there's a lot of discussion about how the data breach laws must be made more strong, that it must include not just personally identifiable information like social security numbers and so on, but it should also include medical data. It should include biometric data. It should include things like your photos and your image and fingerprints and so on and so forth. Now, there are some states that have specific Biometric Information Privacy Act, BIPA. Illinois is one of them. And Illinois actually has the toughest Biometric Information Privacy Act in the US. In fact, Facebook recently had to pay a $500 million fine because they were using images and they were tagging images without the consent of citizens of Illinois. There's also other commentary that says that people must be informed. It's not enough to just inform the state. People must be informed. There are others who argue that companies must be forced to implement security measures. And perhaps one of the most powerful laws protecting data in the US is laws in states like California that require companies that have your data to destroy your personal information if it is no longer needed. In other words, if you've not done any transaction with them for a long period of time, several months, so on, maybe 18 months have gone by, you've never bought anything from them, then you should destroy data related to you. So that's I think a powerful piece. Finally, I want to mention the last piece of law in the US that is designed to protect your data. Very often, your data information, like your date of birth, your home address, your social security number, is very often combined with other documents. And that results in a lot of identity theft in the US. So here's an example of where we do have a federal law that basically says that using false documents to engage in some type of unlawful activity is a crime. And of course, the extent of punishment depends on you know, what did you steal? What is the value of what you stole, et cetera, et cetera. And there are various scenarios in 18 U.S.C. section 1028 that deals with this. But that is, in fact, a set of laws that do exist at the federal level. And this is really a little bit of an exception. So I want to stop here. It's been about 30 minutes since I've been speaking. And what I wanted to tell you is that this is very much an area where there's a lot of change and there's a lot of activity. And I think it's an exciting area to study and be engaged. And it poses a lot of interesting questions, both from the privacy perspective and from the security perspective. And I'll stop right here.
Thank you, Professor Kesan. And now we can start the discussion. I don't know if anyone here would like to pose a question. I have mine, but
please feel free.
Yeah.
Professor, one first question. What's your opinion about the discussion of a federal statute of data protection in US?
So this is a very contentious issue. The main problem is there are those who believe that people like Google and Facebook are just not being honest about all the data processing that they're doing. You remember all this Cambridge Analytica. You remember that whole situation there. So there's a lot of people who believe that. Data is, after all, the currency of the 21st century. There's so much data that is being collected, but more importantly, different pieces of data are being agglomerated. The aggregation of the data is really something that allows companies to get a very clear idea of who you are in a very granular way. So it is a problem. But these companies are also spending a lot of money, literally hundreds of millions of dollars. By one report, it was somebody mentioned that they've spent $500+ million lobbying Congress to sort of not have strict laws. Of course, that has also caused a backlash, and now there are people in Congress who talk about breaking them up and not allowing like Facebook to own Instagram because that allows them to combine the images with the other browsing habits. So these companies are under siege, on various sides. So it sort of remains to be seen, what happens. On the other hand, let me point out that the French, data protection authorities, they fined Google for the activities with respect to French citizens. They fined them 50 million. So there is some rules that, even if we don't have a federal law, if there is a lot of rules and regulations all over the world, then companies who do business all over the world, they do have to comply. So it's not really that simple that, hey, they can get away with it. On the other hand, you have people, professors and so on, who are arguing about surveillance capitalism. There is now a surveillance capitalism going on where basically, you are constantly being surveilled, and this is being monetized. And so, I think this is very much changing. But I have to say that consumers are, of course, agitated, and consumers, of course, don't realize how much information about them is being taken. So there's an informational asymmetry because every individual doesn't realize how much information is being taken about them, and they cannot properly value that information. So you have that issue. Now, on the other hand, companies, they do have to comply. And I mentioned the U.S. Privacy Shield. They do have to comply. So it's not like, there is no legal recourse. So that's a sort of a long answer to a broad question, but there's a lot going on.
And the point too, for these big companies, I don't know if could be better for them to have the rules of the game. Because nowadays in US you have this different statutes, different states. This causes a mess in some sense.
You bring up a great point. Your point is a really valuable one, which is that uncertainty and lack of clarity sometimes is worse than having a strict law, because at least you know what you need to do. And the GDPR is actually a very good example. You need clear, unambiguous consent. That's what the GDPR says. So you can live with that. You can explain what you're doing to collect data, what kind of cookies you're using, so on. The GDPR requires that you present all this information to a consumer, and the consumer can then consent. And of course, the consumer can then change their mind, revoke consent, and you have to remind the consumer again and again that the consent has to be renewed. But there is some clear rules. So if you follow them, then you're okay. So I agree with you. In fact, this type of uncertainty is okay if you're a large company and you have lots of money to spend trying to sort of deal with all these differences, and presenting different websites to, if you're a EU citizen, all this stuff. It's great, but it's not great for small and medium enterprises that will then be forced to simply comply with the most stringent law. So yes, I mean, absolutely correct. I mean, if you've got hundreds of billions of dollars like these large tech companies do, then they actually benefit from some of the chaos. But typically, typically, I agree with you that one of the basic insights in economic analysis of law is that legal uncertainty can create all kinds of additional costs that really are, burdensome.
People, questions?
I have one question.
Please.
Professor, first of all, thanks for the presentation. My question is, today, what are the enforcement measures adopted in the US by the authorities in relation to big tech companies such as Facebook and Google?
So, of course, there is a couple of different perspectives on this, but the Federal Trade Commission that is in charge of regulating deceptive consumer practices has brought a lot of privacy actions against companies, including Google, etc. So there are laws that exist where they're largely contractual. So you say in your terms, of agreement, you're going to do something, and then you do something else. You say, I will not share this information with some third party or so on and so forth, but then you go ahead and do it. Then those kinds of violations have always been enforced by the FTC. Now, the argument that is made is not that these actions don't exist. The arguments, the criticisms of them are twofold. One is they don't do anything except in the really egregious cases. So there's a lot of violations that are not enforced. In other words, the policing is poor. And number two, they say the extent of the fines are not large. You know, basically, it's not like hundreds of millions of dollars are fined. That's not the case. So the benefit that the companies get from your data far exceeds the cost due to the fines. So the environment is such that you can actually continue to process people's PII. And if you get caught, you still benefited from using people's PII without telling them or without properly obtaining their consent and so on. So those are the sort of the criticisms. But I think your question is essentially assuming that that is the case, and you're right.
Thought must not pay. That's one point, I think. People, more questions? Do you have? Anyone?
I have one.
Who?
Yes. First of all, thank you very much for the explanation, Professor. My question is if people here, people in the US are more concerned with their personal data because of what happened in the last elections with the Cambridge Analytica, and since this year there will be another election. So my question is if people are more concerned with their personal data. Thank you.
You bring up a good point. People are concerned, but unfortunately, if you ask the ordinary person, you know, he says, well, what can I do about it? I'm feeling so helpless because, you know, what can I do? I can delete my Facebook account, you know, and many people do that. You know, I can go and try to minimize, you know, have my own domain, don't use Gmail or something like that. So people try to do these things. And people try to sign up for monitoring services to make sure that, you know, if somebody is doing a credit check or so on, you know, so they try to sign up for monitoring services. Who is trying to use your data, who's trying to use your social security number, so on and so forth. So essentially, people do engage in what I call self-help. People are engaging in self-help. I think it is happening. However, the trouble is that they are also being coerced. By coerced, I mean, now you delete your Facebook account, now you are disconnected. now you cannot go look up something, on Facebook. So now you turn off your cookies. You cannot read the New York Times. So the problem is when they try to help themselves, many times the cost for them to try to enforce their privacy is too high. And it just gets very difficult for them. It means I cannot read anything, I cannot do anything, so this is the real problem. So unfortunately, yes, there are people who are very determined and who are trying to engage in self-help, but it's not that easy.
Thank you, Professor. We have another question of Juliana.
Hello. Professor, please. Do you think that in the coming year, the United States will adopt a federal law, data protection federal law? Thank you.
So, if I understand it correctly, you're asking, do you think that the US will have a federal data protection law? That's where I think the political economy of this kind of federal privacy legislation has to be understood. So who are the stakeholders who are affected, and what is their bargaining power? That is what is going to ultimately determine whether we have a federal privacy law or not. The problem is the people who benefit from not having a federal privacy law are large companies with a lot of resources, and they are very concentrated, and they coordinate very well. On the other side, you have ordinary consumers who are uncoordinated, who in our individual loss may not be so high. Each of our losses are not that high. So we are an uncoordinated bunch. So you can see the political economy of this situation is that some stakeholders are very powerful and well coordinated, and the benefits are accrued by these small number of entities, and the costs are borne by millions and millions of Americans, each of whom is individually not affected that much. So what we really need is more coordination amongst consumers and citizens. So as long as there is more coordination amongst average Americans, then I think there will be a federal law. And the fact that the GDPR has been passed, and really it's fairly successful. Now, of course, people are criticizing the GDPR also and saying there's not enough fines, that there's not enough violations and prosecutions. There's been one prosecution against a Canadian company, and then there was this French case against Google I mentioned. So there's not been that many. So there's people who also argue the GDPR is also not that strong. But nevertheless, the fact that the GDPR exists and the fact that companies are able to have something like a equivalent of a federal law, because the GDPR is EU-wide, and the EU is basically as big as the US. So the fact that that exists, I think, provides more support that maybe there will be a federal law in the future. And I think the more average citizens, the more they are upset, the more we're likely to see a new law. Certainly these things are more likely, generally speaking, if there is a democratic administration. So you're right to point out the importance of the election and so on, and how that will affect privacy law.
We have another question of Alexandre. Alexandre, please.
Thank you very much for the excellent presentation. My question is about TikTok and competition law. What's your opinion in the access to the personal data from the population as an element of competition law? I think what are the connections between these issues under U.S. law?
So this is a huge issue, and the basic argument is that having access to your data allows these companies to engage in a lot of anti-competitive practices, because the data that they collect is not being shared. So they can use the data. So people like Amazon, etc., use the data in ways that create barriers to entry for other people to come in. And they have so much data over such a long period of time that their ability to restrain competition is only getting worse. It's only getting, it cannot get better. So that's the competition law argument. The problem is, if you force everyone to share all this information, if that's the solution to this problem, then now you have even less privacy. You know, so part of the problem is everybody recognizes there is a problem, but the question is, what is the remedy? What is the remedy that makes sense? Should it be like a public utility where all this data is shared by everybody? Is that the answer? Okay, maybe, but then then you've really made it almost impossible to have privacy. Because now everybody has your data. So I think that's part of the problem. People recognize that this massive aggregation of data about you can be anti-competitive, and that is what is driving a lot of criticism of people, especially on the Democratic side. So, and of course, even on the Republican side, you have some people who are talking about busting up, Amazon and so on, for this reason. Now, the TikTok issue is a slightly different issue, because that raises a different issue. What you're seeing in Chinese companies is essentially two approaches. One approach is like TikTok, meaning ByteDance, the Chinese parent company, is a Chinese company, and they want to have a US company that is completely separate. So that's one business model. Have a US company and make it truly separate, and that's one approach. The other approach is the Huawei approach. The Huawei approach is, no, we are a Chinese company, and we have international subsidiaries, but we are going to be the Chinese parent. And so the question is the Huawei approach or the TikTok approach, which approach is, or the ByteDance approach and the Huawei approach, which is better? I think that remains to be seen. But Huawei is running into so much trouble with their business model that TikTok is trying to do something different. They're trying something totally different. They're saying this US company is entirely there, So I think it raises some interesting questions as to how this is going to play out.
Thank you.
Thank you, Professor. I don't know if there is another question.
Yes, I'd like to make a question.
Please, Rafael.
Yes. Professor J. Kesan, good morning. You've talked about many important issues this morning in reference to Federal Trade Commission and the institutions that regulate the American system. I'm very interested about what could be the big important changes for the institution, especially concerning data protection and the federal authority that is responsible for the data is the Federal Trade Commission. And how could of course, you talked about statutes and so on, but what could be a good direction of changes to represent? Of course, there is a political economy issue. That's the issue actually, but also the role that the judiciary and the courts make in putting that into effect, and what kind of direction of regulations we could learn and slowly maybe change. If you can comment on that, please. Thanks.
Your question is a great one. That's one of the reasons why I wanted to talk about, for example, tort liability for privacy violations, because that is where the courts are coming in, where the courts are acting like private attorney generals. And the courts are saying, hey, if these people's data has been collected and not properly protected, you have not done what you should have reasonably done. So that is another way of forcing companies to, even if they collect your data, at least they have to protect it. Now, it doesn't solve the other gentleman's question, which is they're collecting all this data and engaging in anti-competitive conduct. So it doesn't solve that problem, but it at least addresses the issue of keeping your data private. Now, there are other people who argue the FTC is not the right agency, and we need a new privacy czar. We need a new privacy agency. We need a new privacy czar. So there are other people who think that way, that their focus should really be on privacy. And you need a agency, you need a commission that really will focus on this. So because the FTC is really not doing enough. And the jurisdiction of the FTC focusing on deceptive consumer practices is narrow, and you really need a broader mandate. So yes, you're right. So one solution is to have a new agency with more powers. Another is, of course, to actually allow some of these lawsuits to go forward, because the problem is that courts have not recognized data insecurity is actually a social harm, and our autonomy is compromised, our privacy is compromised, is not really seen as being a harm that is actionable under tort law, because it's like the data is still there, nothing has happened to your data, now 10,000 more people have it, so what's the problem? This is nothing, this is not really a harm, so this is part of the problem.
Thank you, Professor. One more question. I think we...
Yes.
Oh, yes.
Hello.
Hello.
Thank you, sir. I have a question regarding this legislation issue in the U.S. You said that there's a lobby situation that that prevents U.S. from having a federal.
Just explaining the political economy.
Yes, yes, but you see, California, for us in Brazil, it's a place where all companies, tech companies, are placed, and they were able to have a legislation regarding data protection. So, wasn't there a problem in California? What are the differences between California and the rest of the U.S.?
So, great question. You said, why did the CCPA pass in California? Simple. In California, the state legislature is really not multiple parties. The House, the Senate, the governor, they're all from the same party. So that's first. So these are strongly democratic state, and so they were able to pass it. The people who look at the CCPA, though, point out that it's an example of legislation, but it really is not. There's big differences between the GDPR and the CCPA on the substance. So yes, you pass something. Yes, you can opt out, but okay, I give you the right to opt out, but so what? You can't. If you opt out, you cannot read anymore. You cannot browse anymore. You cannot. So yes, it's true that you can delete your data. That is true. So that is true. And you can check what data they have. And so if they have some incorrect information about you, then you can change it. Hey, this is I am this other Julia. I'm not this Julia. So the information you have about me is wrong. I don't have a credit card problem. I don't have a debt problem. Fix it. So that is good. So keep in mind that this helps these companies too. It helps them to have good, correct information about you. So you see, the point here is the law that was passed was limited, but also it was passed in a way that was quite helpful to these people. So I think it's too simple to say California passed it and somebody else, how come? I think yes, but you really should look at the law and look at also the political economy of California, of course. But in some ways, the law is actually helping to ensure that good, correct data is being collected about you. Does that make sense?
Thank you. More questions? No? I think we reached our time. So I would like again, one more?
Hello. I have one last question regarding the federal legislation. And first of all, thank you for your presentation, Professor. And if it's possible, and if we still have time, I would like you to comment about the recent decision of the European Court of Justice about the Privacy Shield. And if you think that this decision could make the American companies support a federal legislation in order to guarantee the transference of data from Europe to America.
Yeah, well, we're definitely the U.S. Privacy Shield is something the government was really pushing because the companies are pushing. So that's why I mentioned there are these two frameworks, the US-EU framework and the Swiss US framework. So I do think this USC Privacy Shield is important. Now, will that result in the new laws being passed, which is your question? I think it cuts both ways. It cuts both ways because it allows these companies to say, look, there is now a privacy shield. everything is fine. Everything is good. We don't need a federal law. We are fully complying with GDPR. So there's no problem. So I think it cuts both ways. On the other hand, you are right. It does allow people who want legislation to say, hey, the GDPR did not cause so much chaos. And there's good mechanisms in place. So let's at least have one federal law for privacy. The concern that the companies have is once there is a big federal law protecting privacy, then that is the camel's nose in the tent. And over time, this law might become stronger, bigger. So you see, that's why the privacy shield actually, you could argue, makes it harder to have a federal.
Thank you.
Does that make sense?
Yes.
I think there is another colleague that would like to question. No? So I would like to thank you, Professor Kesan. For us, it's a great honor to receive you here with us in our webinar. We expect to receive you again in other opportunities. And I expect to return to Illinois, to Urbana-Champaign, to be with you in a summertime, because in the winter it's too hard for a Brazilian guy. But Professor, thank you very much. I don't know if you would like to say something.
Yeah.
But for us, it's a great opportunity. Thank you.
Yeah. I've been to many parts of Brazil, actually, but I have not been to Rio Grande do Sul. But I have been to Sao Paulo, and I have been to Rio, and I have been to Brasilia, and I have been to Piracicaba, and a whole bunch of other places. So a lovely country, and so it's a nice way to engage. Thank you so much.
Next time, I would like to invite you to be here with us in a presential web seminar.
Indeed, happy to do it. It really was a very nice discussion. Thank you so much.
Thank you, everybody. Thank you, people. And bye.
Bye-bye. Take care. Bye-bye.